Companies Act Section 15, Alteration of Memorandum or Articles to be noted in every copy. Introduction. Section 15 of the Companies Act emphasizes the importance of maintaining updated versions of a company's Memorandum of Association and Articles of Association. These foundational documents define the company's objectives, rules, and internal governance structure. As companies evolve, they may alter their memorandum or articles, and Section 15 ensures that any such alterations are reflected in every copy of these documents. This requirement promotes transparency, accuracy, and consistency, ensuring that all stakeholders are informed of the current governing rules and structure of the company. One requirement to note alterations in every copy. When a company makes alterations to its Memorandum of Association or Articles of Association, Section 15 mandates that these changes must be duly noted in every copy of these documents. This is a critical requirement to ensure that all stakeholders have access to the most up-to-date and accurate versions of the company's core governing documents. Key aspects of the requirement. Uniformity across all copies. Every copy of the memorandum or articles, whether distributed to shareholders, creditors, potential investors, or filed with regulatory authorities, must reflect the changes. This ensures uniformity and avoids discrepancies between different versions of the company's official documents. Reflecting amendments. If there are any amendments, such as a change in the company's name, registered office, capital structure, or business objectives, these must be incorporated into all copies of the documents. This step is crucial because it ensures that anyone referring to these documents is aware of the latest information governing the company. Legal purpose. The purpose of this provision is to prevent confusion or misunderstandings that could arise from outdated versions of the memorandum or articles. Stakeholders, including members, creditors, regulatory bodies, and even third parties such as potential investors, rely on these documents to understand the legal framework under which the company operates. Any omission of alterations can lead to misinterpretations and may adversely affect the company's operations, decision-making, and legal standing. Consistency for stakeholders. For stakeholders, access to the most current version of the company's memorandum and articles is vital. Members, shareholders, and creditors must be able to make decisions based on accurate and current information. Regulatory authorities also require updated copies to ensure compliance with legal requirements. Ensuring that all copies reflect changes promotes clarity and transparency in the company's internal and external dealings. 2. Penalty for non-compliance. Section 15 introduces penalties for companies that fail to comply with the requirement to update all copies of their memorandum or articles to reflect alterations. The penalty acts as a financial deterrent to ensure that companies adhere to the requirement, thereby safeguarding the accuracy and reliability of their governing documents. Penalty for issuing inaccurate copies. Imposition of penalty. If a company issues a copy of its memorandum or articles that does not incorporate the alterations made, it becomes liable to a penalty. The penalty is set at 1,000 rupees per copy that is not updated to reflect the changes. Scope of penalty. This penalty applies not only to the company itself but also to any officers who are responsible for overseeing the accuracy and distribution of these documents. These officers hold the duty to ensure compliance with Section 15, and failure to do so may result in financial consequences. Ongoing liability. Each non-compliant copy that is issued can result in a separate penalty, meaning that the total financial liability can accumulate based on the number of outdated copies issued. This could become a significant burden for the company if it fails to correct the oversight promptly. Emphasis on responsibility and accuracy. The imposition of penalties reinforces the responsibility of the company and its officers to ensure that any alterations made to the memorandum or articles are properly documented and distributed. This is not merely an administrative requirement but a legal obligation that helps uphold the company's transparency and accountability. Administrative oversight. Officers in charge of maintaining these documents must ensure that all updates are incorporated into every copy distributed, whether in physical or digital form. This requirement places a significant emphasis on the importance of accurate record-keeping and proper internal administrative procedures within the company. Financial deterrent. The penalty structure is designed to encourage companies to take the updating of their documents seriously. The financial consequences of non-compliance serve as a deterrent, ensuring that companies prioritize this task and avoid any unnecessary penalties.